Remember, in his petition, the Chief Minister had submitted that the sanction order was issued without due application of mind, in violation of statutory mandates and contrary to constitutional principles, including the advice of the Council of Ministers. According to the petition, including Council of Ministers is binding under Article 163 of the Constitution of India. But today, the judge has ruled that the governor can take independent decisions in exceptional circumstances such as this. It should be noted that the Karnataka High Court has upheld prior approval for investigation under Section 17A of PC Act. For the BJP and the JDS, it is their first victory, one that had taken up a campaign against the alleged irregularities by the Congress government. With a ruling against the Karnataka Chief Minister, is Siddaramaiah's position set to weaken? And how will this now play out for the politics of Karnataka? We'll deep dive in that in just a bit. But first up, let's also tell you what the Karnataka High Court has said in its order. The first finding is that the complainants are justified in seeking approval of the governor. The second finding says that the governor can take independent decision in exceptional cases. The third finding says that no fault can be found in the action of the governor. And fourth, equally important, that the governor order nowhere suffers from any want of application of mind. The fifth says that alleged hottest haste has not vitiated the governor's order. The sixth says that facts in petition are undoubtedly requiring an investigation. But prosecution sanctions against Chief Minister is not new. Let's also give you a timeline of how they have been happening. Also, it's not new to Karnataka particularly. In 1995, Tamil Nadu's Governor Mari Channa Reddy had approved the prosecution of Tamil Nadu's Chief Minister Jayalalitha on corruption charges. In 1997, former Bihar Chief Minister Lalu Prasad was also the subject of such a similar sanction over the fodder scam case by Governor A.R. Kidwai, who granted sanction to prosecute the RJD chief following a request from the CBI after delaying a decision for more than 2 months, this citing inadequate evidence. Former Maharashtra Chief Minister Ashok Chavan was named in the Adarsh Society scam. At the time, several requests for prosecution sanctions were denied by then governors. In 2016, with the BJP Shiv Sena government in power in the state and centre, C.V. Rao granted sanction to the CBI. Now, in 2011, Karnataka's Governor H.R. Bharadwaj had accorded sanction to prosecute Chief Minister B.S. Yediyurappa over allegations of denotification of land acquired by the government. This apart from other charges. This, of course, is a case in Karnataka itself. Yediyurappa was forced to resign. And so the question we are posing, can Siddaramaiah remain Karnataka's Chief Minister, and should he now step down?
That's the only option. We filed a writ petition and GM res classification. So there is a writ appeal that is available to us at the first instance. And I think all preparations are ongoing.
It needs to be investigated thoroughly and impartially. To conduct the investigation impartially, Siddaramaiah needs to be resigned.
It is not only victory of the Bharatiya Janata Party, it is also the victory of the people of Karnataka.
After go through the judgment, I will discuss with the legal experts and also with my cabinet colleagues and party and also with the High Command. What action to be taken legally to be spelled out.
No question. My Chief Minister has not done anything wrong. He is not involved with any scam. It is a political conspiracy by the BJP to all of us, to all the opposition leaders in the country.
right, and with that, let me now introduce our esteemed panelists today. I'm joined in by Madhu N. Rao, who's a spokesperson for the BJP in Karnataka. Shatabish Shivanna, who's the counsel to CM Siddaramaiah and spokesperson of Karnataka Congress. Also joined in by Sumit Chandar, who's a renowned advocate at the Supreme Court, and Paramveer Singh, who's a political commentator. Shatabish, of course, the big question that everybody is asking, that when Yediyurappa was convicted and jailed, if it was not a problem back then, why is it a problem now? Because remember, it was your government which was there at the center.
See, good evening. I don't think you can compare the events and circumstances that transpired in Yediyurappa's scam as along with the one in Siddaramaiah's scam, because they're two distinct things. Prosecution was granted. There was alleged denotification in Yediyurappa's case. His son received direct money into his bank account in the name of a trust. But here, in the case of Siddaramaiah, there are just conjectures, surmises, and speculations made by certain private respondents. And I feel the Honorable High Court, although I respect the judgment of the Honorable High Court, but I can point out at least a dozen of irregularities only on facts. The Honorable High Court has stored the lines of the imaginary speculations that are narrated by the private complainants. He has considered relevant
So, Shatabish, you will agree that the Lokayukta did carry its investigation. It arrived upon the right findings to have a Yediyurappa get convicted and jailed. Perhaps an investigation is what is the bone of contention over here, and that is exactly what the Karnataka High Court has come up with.
Correct. Now, let me just clarify this. CM Siddaramaiah and the governor has not accorded sanction to prosecute. In fact, in his order, his order was twofold. One, granting prior approval to investigate. Two, sanction to prosecute under Section 218 of the BNSS. And during the course of court proceedings, the learned Solicitor General comes and clarifies, I am sorry, it was erroneous for the governor to issue sanction to prosecute the Chief Minister, and this order must be only looked at as prior approval to investigate. You know, it surprises me. How can the High Court come and clarify what the order of the governor is? You just look at the widespread ramifications that this will have. Tomorrow, an administrative person passes an order, and then someone aggrieved by it challenges it in the High Court, and they come to the High Court and say, no, please look at it in this lens, don't look at it in that lens. It is absolutely ridiculous. And the High Court also, justifies this, clarifies this. Are they justified in doing
All
that?
right, Sumit Chandar, I'd like to quickly bring you in. I'm sure you will agree that the Karnataka High Court has very much upheld the decision to an investigation, of course, under Section 17A of the PC Act. And yes, I agree with Shatabish that as far as the BNS is concerned, they have struck down the Section 218, which was also applied by the governor. But having said that, the sanction to prosecute only arrives depending on what is discovered in the investigation. So what is rocket science about this?
The rules, the procedures, the guidelines, they have all been laid down very clearly in law. And you have to follow the due process defined in law. Of course, logics and things can be discussed over a cup of tea, no doubt. But the rule of law has to follow when an investigation takes place. Investigation under Section 17A is a very defined investigation as given under the Act. And the other aspects to it is that it is not only an investigation which has been sanctioned now by the High Court, has only said that this order per se with respect to Section 17A is okay to be going ahead. But that also needs to be seen in law, which I'm sure in appeal it would be taken up, whether it is right for this Section 17A, which came up somewhere much later than when the offence had been committed. So whether this will have a retrospective effect or not. These are legal aspects which still needs to be seen. It has not come to a final conclusion. And the law will be laid down, if not by the High Court in single bench, but might be in division bench, but that's something we have to see with times to come.
All right, Shatabish, I have one more question for you before I bring in my other panelists. You know, interestingly, in the case of Yediyurappa in 2015, the entire matter was, in fact, the Karnataka High Court had overturned the prosecution, saying that the rightful considerations by the governor back then, Mr. Bharadwaj, had not been made. How do you respond to that? Let's talk about the rightful consideration when it comes to the governors. Over here in 2015, why did the Karnataka High Court overturn it then?
No, see, now the law is laid down. And back in the day, I think a learned legal luminary who was the governor of Karnataka, Dr. Hansraj Bharadwaj, had issued an order of sanction to prosecute Yediyurappa. And in his specific order, the court felt that there were certain, political conspiracies behind this, and they chose to quash it. But in this case, we're still at a primitive stage. Now, my only question to you is this. When the order of the governor issues a prior approval under 17A and both sanction, how can they retract from it? Does it not suffer from total non-application of mind? That is the simple question.
Madhu Rao, let me bring you in. Shatabish is still adamant on calling this non-application of mind. This when the Karnataka High Court judge has already stated that there has been due diligence done and there has been application of mind, yet they continue to call this as a non-application of mind. And not to forget, they have already started crying foul, saying that there is a political vendetta. This is a conspiracy being hashed by the BJP and the JDS.
Akanksha, good evening. All that I can say is old habits die hard for the Congress. They can't accept anything which goes against them by the courts. Now, point one. Point two, after all what the court has said, let me read it. The facts narrated in the petition would undoubtedly require an investigation. This has been our stance right from the beginning. Don't we know what happened in 1998 with regard to the denotification? Are we not aware as to what happened in 2004 with regard to the land coming on to the brother-in-law? Are we not aware what happened in 2010 with regard to the gift deed having been made? Are we not aware as to what happened in 2017 when an application was being given for reconsideration of the alternative sites? All these things have happened when he was in the helm of the affairs. Therefore, the court came to a conclusion. These are all parameters which needs to be considered for investigation. After all, what the court has done today, under 17A, investigation needs to go on. What is wrong with Mr. Siddaramaiah to even face an investigation, Akanksha? I mean, this is really...
Madhu Rao, by that logic, wait for the findings of the Lokayukta to come to the forefront. Why demand the resignation just yet?
I will come to that. Please play the record of 2011 when Mr. Siddaramaiah used to tell Mr. Yediyurappa, let the investigation go on, you step down. You come clean, then you become the Chief Minister. We are only showing the mirror to Mr. Siddaramaiah. Mr. Siddaramaiah, you are the very same person who told Mr. Yediyurappa, come down, you face the investigation, come with flying colors, become the Chief Minister. Same thing we are telling Mr. Siddaramaiah. Do the same thing. You are the person who told this very thing in 2011. Follow what you said. Point one. Point two, I want to only ask the aspects what my good friend Shatabisha Shivanna told. These are all put to dustbin by this High Court. All those judges, all those arguments have been set aside. If they want, let them go on appeal. That's a different issue.
I think Shatabish wants to come in on that. Shatabish,
go on the same point. I think it is incorrect.
If it is about following the moral high ground, practice what you've preached back in the year 2030.
No, firstly, the High Court hasn't thrown our contentions in a dustbin. In fact, they have accepted our contention and they say this is not a sanction to prosecute under 218 and it is a prior approval to investigate.
And once you say it is wrong, once say it is correct.
1 second, sir. I did not interrupt you. Please give me the time.
Shatabish, come on.
I did not interrupt you. Please give me the time. See, I don't know how justified it is for the learned single judge of the High Court to come and clarify a governor's order, though his order doesn't contain all these aspects. Now, Mr. Madhu and Rao was talking about acquisition, land denotification, or conversion, sale deed, gift deed, etc., etc. But they're not able to pinpoint a single decision taken by the Honorable Chief Minister or a recommendation made by him.
I will come on that, Akanksha.
One second.
Go ahead.
One second.
But before we do that, when you talk about let me in fact come in on that first. I'm sure Shatabish, you will agree. Governor Gehlot himself has quoted the Madhya Pradesh state of Madhya Pradesh versus state police. That entire case has been quoted of 2004, where both two sitting ministers of the state were accused of land irregularities, and that time it was the BJP government in the state and in the center. The governor decided to go ahead with the decision to get them prosecuted. So now
let me just clarify that.
So and that was upheld by the court.
the moral high ground that Madhu and Rao was talking about. Now, there is the Lokayukta, a special investigation team appointed by the Honorable Supreme Court, who has filed a charge sheet against Mr. H.D. Kumaraswamy, and they are seeking sanction for prosecution against him.
No,
If
no,
they
he is
are so
confused.
highly
Shut up,
moral,
Ace, come on.
ask him to resign.
I will
Ask
clarify
Kumaraswamy
it.
to resign.
I will
Why have you
clarify
given
it.
him the mantle of a union
I will
ministry?
clarify, Baba.
Why don't
Right.
you
I will
apply
clarify.
Madhu
Right.
Rao,
Akshay.
that's also the
So,
question
Kumaraswamy-
that's been posed by the Chief Minister himself. He's saying that when H.D. Kumaraswamy was being inquired for in the land mining case, why didn't you let him resign back then?
You
May
made
I-
him a
may I
union
say-
minister. There is
No,
a direct recommendation made by him.
May I say something to my Congress spokesperson? With regard to the Kumaraswamy's case, whatever was pending, the Supreme Court told, please file the report to Supreme Court. They have not done
When the
it.
charge
You
sheet has
please, one
been
minute.
filed now,
Shatabish, please.
when there is a
Shatabish,
sanction
please.
for
Let me answer
prosecution
this.
request pending
Don't
before the
get
governor.
nervous.
Shatabish,
Kindly.
please
have
allow
made
him
Come
to
on,
speak.
this
He
is not
did. He
correct.
let you
Please
make your
ask him to
point,
resign.
Shatabish. Let Madhu
This
and
is
Rao
not
speak.
correct. This is not correct. Now Supreme Court told the SIT has to submit the report to the Supreme Court. Please submit the report. What were you doing? You got into government with Kumaraswamy and you kept quiet. You please ask Siddaramaiah ji, why did you do like this? Not to everyone else. Point one. Point two. On the fact of the matter that Shatabish was telling no signature was done, nothing was there. How did you know that he made? Let me also educate the Congress persons that in the Delhi High Court also in a similar case of 17A, preliminary inquiry against unknown offenders is not strictly barred. That is what this court is also done. Even if assuming that he has not done, let there be an investigation. Why are you running away like this? You are a chief minister,
No,
Baba.
nobody.
You are not some thieves to run away saying that I have not done anything. You stay there. Let me see. You please tell the whole world. Yes, I am the chief minister. I will face the tune. I will resign. You are not doing all
All right,
these things.
Shatabish,
No,
go
why-
ahead. Go ahead, Shatabish.
There-
I'm sure he
see-
wants to come up with a
if-
rebuttal. Shatabish,
No,
you
see-
know, earlier during the day on CNN News 18, you said that there is no criminality on record to prove that he ought to be investigated. But you know, the investigations have to happen, right, to get to the bottom of the entire matter, not to forget the fact that there has to be preliminary investigation only so that there is a discovery if there has been any cognizable offence.
See, no one is opposing an investigation. We were only before the Honorable High Court challenging the validity of the order of the governor. Had he given only permission to investigate, then this issue wouldn't arise at all. But he, without
What
applying
is
his
sanction
mind,
to
he went
prosecute?
and-
Why are
What do
we
you mean?
why
What
are we
do you mean
harping
is
so
this?
much on the sanction to
What do you
prosecute?
mean?
I'm sure Sumit Chandra, please come in on this. The sanction to prosecute can very well follow after the findings of a preliminary investigation. Correct me if I'm
Let the
wrong.
investigation.
Sumit Chandra.
Yes. Section 17 only ensures that the governor will give an approval for a sanction, which has been done in this case. Investigation, of course, is necessary. And I'm sure the investigation has to take place in any case. So, but of course, since the investigation is about a chief minister, sitting chief minister, of course, you need a sanction from the governor, which has been given in this case. So it's not that anything other than an investigation is going to take place. And I'm sure every citizen of this country, when an investigation takes place, it is their moral duty to participate in that investigation. Nothing wrong. The question here is whether that sanction itself was right or wrong in law, not otherwise.
Exactly.
Sanction was there, investigation will take place. What needs to be seen was whether it was followed a due process of law for that sanction to take place. Nothing
Paramveer
else.
Singh, I'd like to bring you in. If there is a change of guard in Karnataka and if there is a different chief minister to come into the picture, many are asking the question, is this going to be a betrayal to that Dalit backward voter who cast their vote for Siddaramaiah and not for the party? Because remember, it was the Dalit and the backward voter that ensured the victory of Karnataka Congress.
Akshay, this is really a setback for the Congress government in Karnataka, Mr. Siddaramaiah in person, and Mr. Rahul Gandhi. As far as he was doing so big thing before the election, and this is what they are going to deliver it now. And above all, this judgment has opened up Pandora box of political turmoil, which is coming, which we will be seeing in the coming few weeks only. There will be a change of guard. There will be a new chief minister. Mr. Siddaramaiah will have to come down. And we have seen that there was a power struggle after the elections for the post of the CM. That will definitely ensue within the coming few days or few weeks. And that is Mr. Siddaramaiah was the face of Congress party in Karnataka. It was a mandate in his favor, as you rightly said. It was a mandate in his favor, not in the favor of the Congress party. And above all, Mr. Rahul Gandhi was going around the country with his yatra, Bharat Jodo Yatra, and he was credited for that for the victory in Karnataka. These things have been shattered. Those dreams have been shattered. And above all, this Muda scam or any other property scams or allegations have been leveled against the Chief Minister. There were serious irregularities. I have not forgotten the time when Bangalore was swept in the rainwater. These properties which have been sold direct, these were the reasons. And above all, Mr. Siddaramaiah has been trying to score the brownie point. If I want to point out a point, there is a notification recently, if I remember, Mr. Siddaramaiah has issued a notification for Anganwadi workers to be fluent in Urdu language. So these are the brownie points. This is just a bit of an iceberg here.
All right. I want to quickly bring in Shatabish. Shatabish, time and again we've seen how the Congress has started attacking the judiciary. This time around, the legal advisor to Mr. Siddaramaiah, Mr. A.S. Ponnanna, has also talked about how the BJP and JDS are using the judiciary for political gains and for political conspiracy, to further political conspiracy. Isn't that shocking rather?
No, I mean, there is a trend. There is a trend, and with all due respect to the learned judges, but we see a trend wherein there is some sort of biasness or inherent bias that is creeping in. It is unfortunate. We may be wrong, we may be right, but it is very unfortunate.
All right, Madhu Rao, I'd like to give you time.
I think I strongly oppose such a thing, that too coming from an advocate. I think this is uncalled for. I think Siddaramaiah, please, you can, Shatabesh, you can go on appeal. That's a different issue. I being a lawyer, you being a lawyer, you cannot talk like this. The point is simple. If you allege some sort of unfairness and all, you please go on appeal. But you cannot make accusations against the judiciary. Point one. Point two. I mean, I'm really appalled by the attitude of the Congress party, especially. Now, Siddaramaiah says, let me discuss with my counterparts, let me discuss with the Council of Ministers, and Mr. D.K. Shivkumar comes and says, oh no, he has not done anything wrong. I mean, who's High Court? High Court has told Baba, D.K. Shivkumar ji, please try to understand. Don't try to safeguard a person who is to go and undergo an investigation.
All right, I'm afraid I'll have to leave it at that, because remember, the question over here is, whose advice should one be taking? If the governor is to take the advice of the Council of Ministers, these are the Council of Ministers who work under the Chief Minister, who is the accused in this case. Many thanks to you, gentlemen, for joining in on Plain Speak. And with that, let me quickly bring in former Karnataka Chief Minister and MP, Mr. Jagdish Shettar, who is also joining us live right now on Plain Speak. Mr. Shettar, thank you so much for joining in. The consideration for moral ground, the entire resignation that's being demanded right now, why are you demanding the resignation on moral grounds, this when the investigation is yet to begin?
Yet to begin means, according to governor's order, investigation will start, and they may file FIR also, and even officers who are working under the center of the Chief Minister, state government officers, they have to go investigation. How it is possible, if he continued as a Chief Minister, how it is possible to investigation properly and honestly? It will not be impartial. It will not be an impartial investigation. So he has to resign unless and until investigation is completed. He has to resign from his post. If not, there will be no proper handling, proper justice will be caused to the what are the issues raised by the.
Mr. Shettar, Mr. Siddaramaiah has questioned the demand to resign, asking why wasn't H.D. Kumaraswamy asked to resign at the time of the inquiry in the land mining case. So why should he resign now?
That issue now recovered by this present government. It is a 10 years, 15 years old case. Now he recovered up because of the Muda scam. CM himself is involved. So it will not be connected. Here the governor has given the prosecution sanction, investigation sanction. And Kumaraswamy, whatever the action, whatever the put forth, they have to put forth. And the government is there. Government has to take action. Why he has to resign, Kumaraswamy? There is no order from the any constitutional head. So here constitutional head is governor, and he has given the permission that creates. So because of that, CM Siddaramaiah has to resign on moral ground.
Mr. Shettar, if Siddaramaiah steps down, will a change of guard for the chief ministerial position of Karnataka mean betrayal to the backward class voter, which has been Mr. Siddaramaiah's voter base?
It is not a question of caste creed, because scams on the ground of the scams, if anybody comes down and he resigns, it is not because of his mistakes, his default. It should not be compared with a caste because of his own fault. Siddaramaiah himself, he is a beneficiary. He and his family members are the beneficiary of this Muda scam. So you should not compare with the caste and creed regarding all these scams.
All right, I'd like your thoughts on what the Congress has been alleging. They are calling it a political conspiracy, a political vendetta by the BJP and the JDS. In fact, the legal advisor to Siddaramaiah has said that you are using the judiciary to further political conspiracy against Siddaramaiah.
Conspiracy means they are making allegation against the judiciary also. It shows when the case is pending before the judiciary, High Court, at that time they criticize a lot about the Honorable Governor, not about the BJP JDS. Now they started allegations against the judiciary also. It is very dangerous. With the dangerous position they have taken, it is not a good thing for the democracy. It is not a good thing for the constitution. So when there is a jurisdiction, when there is a justice, when judiciary, we have to believe in the judiciary. Judiciary verdict is a final. So unnecessarily you should not make it a party. Judiciary make it a party in this your political game. It is not a good thing for the democracy.
All right, Mr. Shettar, many thanks to you for giving us your precious time and inputs on that news story. And with that, it's time to slip into a quick break here on Plain Speak. But coming up next, politics over Badlapur rape accused encounter rages on. This, as the opposition has already called it murder, the state and police are calling it self-defense.
rest classification.
ಒಂದು ನಮ್ಮ ಮುಖ್ಯಮಂತ್ರಿ.
On that note, allow me to introduce to you our experts joining us this afternoon. We have Surabhi Hodegere, spokesperson of Karnataka BJP, with us, along with advocate from the Supreme Court Sumit Chandar. We also have political commentator Paramveer Singh with us on the broadcast. My first question is to Surabhi. Given the political reactions coming in from the Congress, we've heard it from Deputy Chief Minister Surabhi, who has, in as many words, while backing the Chief Minister, said that we will weigh in on our legal options, but this is pure political vendetta against Chief Minister Siddaramaiah.
First and foremost, I congratulate the people of Karnataka because today truth has triumphed in a way that it stings a little for the governing party, but so be it. We have been, as the opposition party here in Karnataka, we have been pulling this issue to the forefront, fighting through different on the street, legally, etc., etc. But the particular case in question is the case of the Chief Minister questioning the Governor's order for sanction of prosecution. And today the fact that this has been dismissed goes to show that one, our judiciary is committed to upholding constitutional values that clearly the Congress party has been negligent of. This was not a trial of whether Mr. Siddaramaiah is guilty or not. This was a mere sanction to investigate. How can we, when there are such strong allegations, and this has been reiterated in the order today, that these allegations are not to anybody else but to the family members of the Chief Minister himself, who, mind you, has been in some position of power in the last 30 years. Therefore, is liable to have, those allegations could be true. Therefore, this is a matter of whether investigation should happen or not. Why should the Chief Minister be protected from prosecution or investigation when these allegations are incredibly strong? That is what is going to be investigated, and we see this as a victory. But more than anything, I'm sure that the legal advisor to the Chief Minister, as well as the Congress spokesperson, will have much to say on the legalities of it. But let me give you the political perspective. The political perspective is that when somebody has been saying that I've been in politics for 40 years and I'm clean, if that is so, then you should willingly resign and make sure that you are investigated by a competent authority. That is the expectation that people have, because CM Siddaramaiah has been saying that he has no black mark on him in terms of corruption, no sort of allegation against him. Here is an allegation that has come, a strong one, that has been debated in the public eye as well as with the governor since December 2023.
But Surabhi has not been pronounced guilty as yet.
No, absolutely. Absolutely. I'm not pronouncing him guilty. I'm not a court of law. But there is an investigation agency for them to conduct a fair investigation. It is not legally mandated, of course, but in the eye of the public, it is the rightful moral thing to do, which is for Siddaramaiah sir to resign and ensure that he faces the investigation fairly. How can somebody who is in his
and the High Court has cleared the way for that. Surabhi, the High Court has cleared the way for an investigation. The Chief Minister can be prosecuted. But I want to take your question to Shatabish Sevana, Siddaramaiah's counsel, with us on the broadcast as well. He's of course speaking for the Congress party here. Shatabish, tell us a little bit about what would you say to the manner in which the BJP has come out to seek Chief Minister's resignation. They say that the Congress party kept saying that the governor did not go by the advice of the cabinet, but the High Court has now come out to say in as many words that this is an exception, that in this particular case the governor was free to act in the manner in which he thought was right.
First and foremost, I want to answer to the political conspiracy that is being hatched by the political opposition, because I feel the public, the people of Karnataka very well know the credentials of Sri Siddaramaiah, his honesty, his integrity and whatnot. He has led a life that is impeccable, whether it be personally or politically. Now, the order of the governor was twofold, and this is where the confusion arose. One, he granted prior approval to investigate, and also he granted sanction to prosecute. He did both the things in one breath. And today the High Court has clarified that this order of the governor will be treated only as a prior approval to investigate the matter and not be regarded as a sanction to prosecute. Number one. Number two, insofar as 17A prior approval is concerned, there must be some recommendation made or decision taken by the concerned public servant against whom these allegations are made. Now, insofar as the land is concerned, it has its own history of 30, 40 years. And if the opposition or the private respondents could point out a single decision taken by the Honorable Chief Minister or any recommendation made by him, then we will bow our heads down and we will accept anything. But you can find absolutely nothing. And insofar as the aid and advice is concerned, yes, the governor is required, constitutionally mandated to act as per the aid and advice of the Council of Ministers. However, there are few exceptions. And the High Court today has said this is one such exception. Fine, even if I'm conceding to that for a moment, if he accepts...
Welcome back. Now, the accused in the Badlapur child sexual assault case was shot dead by the police after he allegedly snatched a policeman's pistol and shot an officer in an attempt to escape custody. Cross-firing incident occurred while the accused was being taken to the Thane crime branch officers in connection with an inquiry into a separate case that was filed by his second wife in the year 2022 alleging sexual assault. Meanwhile, politics has erupted over the Badlapur encounter. While the opposition calls it a cold-blooded murder, accusing the state of trying to shield someone, the Shinde Sarkar has claimed the cops fired in self-defense. Here's what the cops claim that led to the encounter of rape accused Akshay Shinde. When we reached Mumra bypass, the accused snatched the ASI More's revolver. This is the version coming in from Thane police. They also say that there was an altercation and in the process, More's revolver was loaded. In the scuffle, the gun went off and a bullet hit Nilesh More's left thigh. Akshay Shinde took the gun in his possession and shouted, "I will not spare anyone." Then he fired 2 more rounds, but thankfully none of us were hit. To protect me and my fellow cops, I fired 1 round at Akshay Shinde. Akshay Shinde was hit and he fell to the floor, lost control of the gun. We took control over Akshay Shinde and took the vehicle to Kalwa Hospital. And so the question that we are posing as far as Akshay Shinde is concerned, is this a murder or self-defense? We'll be taking that question with our guests in just a bit.
आरोपी ने पुलिस का रिवॉल्वर छीन के जो पुलिस के साथ पुलिस के ऊपर फायरिंग की, मुमरा पुलिस स्टेशन में पुलिस के ऊपर जानलेवा हमला करने का गुनाह रजिस्टर किया गया है और उसमें जो आरोपी है उसका देहांत हुआ है, तो उसके बारे में एक अकस्मात मृत्यु रजिस्ट्रेशन किया गया है। दोनों का तपास थाना पुलिस कर रही है।
ये तो पूरा कोल्ड ब्लडेड मर्डर है।
उसने एपीआई नीलेश मोरे इसके ऊपर फायरिंग की। नीलेश मोरे जख्मी है, घायल है और इसीलिए पुलिस ने खुद के बचाव के लिए ये कार्यवाही की है।
And Sajid Supariwala, who's a leader of Shiv Sena UBT, is joining us live on the broadcast, as is Mr. S.D. Vindlesh, who's an advocate. I'm also told that I'll be joined in by Dr. Jyoti Wagmare, who's a spokesperson of the Shiv Sena. In fact, he'll be joining in just a minute. But Sajid, if I could begin with you. Sharad Pawar has said that the lackadaisical approach of the Home Department in Maharashtra is suspicious. Do you agree with that?
Absolutely, it is very shocking to see all these things happening. Now the accused has been having so many guts that suddenly he's taking up the revolver of a police officer, and as per the reports which have been shown and in the media and what I have studied and seen, it is highly shocking that how much bravery, or I will not call it bravery, but how much daring he could get, that he could do this. I mean, he went to this extent only because all law enforcement did not put him on a fast track. He should have been punished immediately with the rape of the minor. How could he be served in the jail? I've heard that in the lockup also he has been demanding certain food and all. It is very shocking that the accused of a rape of minors is being shown so much like freedom to talk in that manner. And also they should, the law is totally so bad over here. The law and order situation has become so bad in Maharashtra, it is very shocking. The first thing is that nobody has the remorse also. The rapist is not having any fear that he will be punished later on. And he should have been given a death sentence immediately. I mean, they should not even wait. In fact, castration is the solution to all this.
But Sajid, the question that everybody is posing right now is that the opposition is more concerned in terms of whether or not this was an encounter. You've heard the kind of reactions that are coming in, calling it a cold-blooded murder. And if it is being called a cold-blooded murder, then where are the sympathies with the rapist? Or with those minors?
The sympathy is not with the rapist. The sympathy is not there. This is the anger of the people, that why he was not punished, why he was not given a death sentence immediately, and now why this encounter? What is the reason? What are the reasons behind that? Why is the principal of that place or the trustee of that place, the educational institution,
Why is he not punished? Why is it not questioned that why such a person who has such a bad track record has been kept in a job, in a school where there is minor girls studying? It is very shocking. Why was there no precaution? Why was there no record?
SD Vindlesh, I'd like to bring you in.
Yes.
As far as concerns about the lackadaisical approach of the Home Department in Maharashtra is concerned, should that now be laid to rest considering the CID is being handed over the case?
For that, we have to see the seriousness of the offence committed by Mr. Akshay Shinde. Two minor girls, aged about 4 years, they were brutally sexually assaulted. The hymen was also ruptured. And such criminals should not remain in society, or society will be totally vanished from this country. And I don't think such persons should be encountered and they should be finished. Otherwise, if we give the leverage to them, the cases will continue for years together and the punishment will not be there and the victim will not get proper
But Mr. Vindlesh, how confidently can we say that this was an encounter without any investigation being conducted? Because remember, this is what the police, on record, I just narrated the entire sequence of events that has been shared by Thane police. I'm going to come to you, Sajid. Mr. Vindlesh, Thane police has gone on to talk about how this is a clear-cut case of self-defense.
In this case, and it is being headed by the senior IPS officer. And they are conducting whether this was an actual encounter, was it in self-defense also, both the possibilities are. It can be in self-defense, it can be a counter also. So the SIT has already been constituted, they are doing their work and we should wait for it. We cannot form any opinion right on the basis of preliminary things. But this thing is no doubt is a very serious offence and such criminals should not be allowed to stay.
Sajid, please go ahead.
Yeah. I wanted to ask you one thing. I wanted to ask you also on the panel that normally the duty officer who's taking the accused along with them in the police van or something, there is a protocol of maintaining the gun being locked and it is not so easy to open the gun and just keep a fire on fire the police officer like that. How could he do that? How could he just, when he was handcuffed, how could he remove the latch, lock and then he fire on the police officer and suddenly there is more into it. This should be investigated properly. What is the reason behind this? As the gentleman over here also said that it could be self-defense or encounter or whatever. But it is very, very strange at the circumstances. If we are looking at the circumstances, it is very strange that this thing could be happening in a police van when there are so many policemen around. How did he gather the guts to fire the police? And in fact, he had been, if he had been, already been put on fast track and accused of the whatever rapes or whatever the things he has done, he should have been remorse, but he has no remorse because our laws did not go on the fast track. They did not even, the state government should have been taken the responsibility. So many days have happened and now he was taken away. Now every accused, every person who's a rapist and all that, we have seen in our country the laws are so lenient. In fact, there should be proper law and fast track courts are there. Why are they not trying to get the justice done at that moment? And then this encounter happens. Whom are they trying to shield? What is going on? Why is the trustee or the principal of that particular educational institution not taken into inquiry also? Why is there no arrest on the same? There is a responsibility of the institution who are putting these people on jobs without their proper scanning. It is very shocking, and then these things are happening. Everything is very confusing. There is no clarity. Right now, we are very confused about this.
Mr. Vindlesh, how do you ensure that justice is done to the mother of Akshay Shinde? Because she's also crying foul. She's already labelled it as a murder.
No doubt the fast track courts have been constituted to take care of the POCSO cases. But practically, we have seen that the cases run for more than 5 years. And while he goes in appeal and the Supreme Court also, they go in 1 up to 10 years. That means the victim will not be getting any justice. It will entirely depend upon the system. The system has to be constituted, the fast track should work properly because all the courts are overloaded. And the dates are given for months together. Fast track means they should be finished within 3 months. But hardly there is any case which are finished within 90 days. And they take more than 3 to 4 years at the preliminary at the Sessions Court and POCSO Court. If they go in the appeal, there is another 2 to 3 years. If the person goes to Supreme Court, naturally the justice will be provided to the victim parents at least after 5 to 6 years, because our law is very, very slow.
The other particular allegation that's coming in from the opposition particularly is that the BJP is becoming notorious for running encounters. This is something we've heard from various opposition leaders as well. Somebody like an Akhilesh Yadav has talked about it in Uttar Pradesh. I'd like your thoughts, Sajid.
Yeah, absolutely. See, I'm not even accusing anybody of anything about but BJP. If you go, like I'm talking about the Maharashtra state, let me just think about and discuss on that. Maharashtra state, you see the law being deteriorated in so bad condition. The rapists are being let off. Either they are being let off or somebody is trying to shield somebody. This is not the only case in Maharashtra which has happened. There are many other cases also where the criminals have been shielded. There have been accident cases where the criminals have been shielded because they have some political influence, or somebody is a minister, somebody is a minister's son, somebody is a BJP karyakarta, somebody is some other karyakarta. Why are all this shit is happening in our country, and why are we not getting justice for people? And now people are trying to shield. Somebody is trying to victimize, and somebody is trying to shield the rapists. I mean, it's very confusing. All the criminals are being let off. Some days they will go in the jail, they pass some law, and then something will happen. There will be inquiries. Then the rapist's parents will be called in the court. Then the criminal will be let off. This is not the way. This encounter happened because now that he fired the policeman, that's why he has been shot. So it is very confusing. That means we are not shooting the rapist. You are trying to get back at the rapist because you have been shot at. So it is very strange. Why not? Does the law, like the gentleman is saying, that there should be fast-track courts, which should have been, it's overloaded. The courts are overloaded. So why not have...
I'm afraid we'll have to leave it at that. Thank you for, in fact, highlighting the loopholes over here. I'm going to leave this discussion over there. Many thanks to you, gentlemen, for joining in. And with that, let me also remember, Israel has retaliated. Close to 500 people have lost their lives yesterday in an attack conducted by Israel in Hezbollah. And CNN News 18's managing editor Zaka Jacobs spoke to Reuven Azar, who is Israel's envoy to India. This is his first response since Israel launched an aerial assault on Lebanon. Listen in to this exclusive.
If you're saying that Hamas has not got the capability anymore to launch an October 7th style attack, but it's continuing A, to rescue the hostages, and B, to ensure it cannot regroup, why then have you opened a new front now in the north with Hezbollah?
Well, actually, if you would ask me 1 year ago, I would tell you that if Israel had a big enough army, we would have attacked Hezbollah immediately. Because Hamas, in a completely unprovoked way, launched an attack against northern Israel on the 8th of October. And this is completely illegitimate. Hamas is a terrorist organization, is an arm of Iran. And, you know, this is not right. We should have retaliated before. But because of our priorities, because of the fact that we wanted to concentrate in defeating the Hamas terror machine, we postponed our retaliation, and we tried to the last 11 months through diplomatic means to get into a ceasefire in the north that will secure the implementation of Resolution 1701 of the Security Council. Unfortunately, Hezbollah is refusing to do that, and therefore we had no choice but to escalate the situation and put pressure on Hezbollah so they actually agree, and the Lebanese government agrees to implement that resolution that would leave only Lebanese army and UNIFIL forces in the border with Israel.
But the escalation against Hezbollah happened just last week. It started really with the pager attacks, which happened sometime middle of last week. And then subsequently, there have been rocket attacks, airstrikes by Israel. The Lebanese health ministry says over 450 have died in the airstrikes that happened over the weekend. When you started the operation against Hamas 1 year ago, you had Hezbollah not on your radar. So many are saying this is the Israeli government and the Israeli Prime Minister changing the goalposts. Your goal was to defeat Hamas, which you claim you have done, but now you're changing the goalposts because you don't want peace, you don't want a ceasefire.
Well, this would be a misinterpretation of the situation, because Hezbollah has been firing towards Israel for the last year, and we did whatever we could in order to create a situation which we have a diplomatic solution. Now that we have the capability to actually retaliate in a more massive way, what we have failed to do diplomatically, we're trying to do militarily. Now, you have to understand that this is very important. Hezbollah has embedded, since 2006, tens of thousands of rockets in civilian homes in southern Lebanon and in other parts of Lebanon. We know that for a fact. We have shown evidence to that. And we have called, and our Prime Minister himself has called in the last few days, all the civilians that are living in these houses to immediately evacuate those places because we don't want to harm civilians. If you look at the footage of what Israel targeted, you could see that in many places that we targeted, you had a lot of secondary explosions. And that means that we are actually targeting the military capabilities of Hezbollah. And
but
we are
how
not
how can you, Ambassador, say that
civilians.
civilians have to leave? You did the same thing in Gaza, asking civilians to leave before the operation launched. But the civilians there, admittedly by your own admission, are bound to a terrorist organization, whether it's Hamas in Gaza or Hezbollah in southern Lebanon. How can they leave? How can civilians who are bound by these terrorist organizations possibly leave?
Well, first of all, not all civilians are listening to the terrorists. I think we had a challenge in the Gaza Strip that was twofold. The first is that the Gaza Strip is very small and people couldn't evacuate too far. We had to designate humanitarian areas to which civilians could safely go. And also Hamas was trying to prevent civilians from leaving. They were actually at gunpoint trying to make them remain because they used them as human shields. In the Lebanese scenario, we're seeing a completely different situation. We're seeing hundreds of thousands of people actually leaving southern Lebanon to the north. I think that's a good thing because we need, at least temporarily, to have a situation in which all these military installations are evacuated so we can target them.
The forum that sets the national agenda is back.
When there are elections in a country and they give you results you don't like, you call them electoral autocracy.
With an unmatched legacy across India's important cities.
There is no such thing as a BJP foreign policy or a Congress foreign policy. There's only India's foreign policy.
Featuring policymakers at the heart of shaping the nation and economy.
It was this government which has amended the minimum alternative tax.
Alongside India's most iconic voices from diverse fields.
सोनू के टीटू की स्वीटी वो फिल्म थी जिसने मुझे घरों तक पहुंचाया.
Bangalore is absolutely the startup capital of the country.
To spark debate and engage in uninhibited conversations.
एकनाथ जी मुख्यमंत्री बनेंगे, ये बात तो मुझे पहले से पता थी.
In the only town hall that matters and about to get bigger, better and more impactful. CNN News 18 Town Hall.
Exception, he must accord cogent reasons as to why he's differing from the aid and advice. That is not forthcoming in the impugned order, and they say they provide some file notings which I directly allege that it is a concocted one, it is an engineered one.
Okay.
And I'm telling you, politically, nobody can demand the resignation of the Honorable Chief Minister. This is only the first step where we were questioning the validity of the governor's order because he had acted in haste. He had issued a show cause notice within 24 hours.
Siddaramaiah, who may just face prosecution now given the Karnataka High Court's verdict. The High Court, remember, has upheld the governor's sanctions, and hence we do see a little bit of trouble now for Chief Minister Siddaramaiah. Now, the BJP, of course, amping up pressure and saying that the Chief Minister must not continue as the CM given the Karnataka High Court verdict. But the Congress continues to allege political vendetta, and we will be deep diving into this political war of words that's only likely to escalate in hours to come. But that's the big word coming in from the Karnataka High Court. We're picking up several legal reactions on this big story. Listen in.
Who was part of the legal team that was fighting for Siddaramaiah in the Karnataka High Court in this petition. Would you see this as a setback, the kind of observations made in the judgment?
It's definitely a setback, but there is of course an opportunity or a remedy available for appeal. Prima facie, we are of the opinion that there were certain observations that were unnecessary. I feel it was ultra vires of the authority that is vested in the Honourable Learned Single Judge. However, we bow our heads with humility and accept the order as it is today. But we will definitely explore our options. There are certain legal contentions that need to be addressed, and we will explore all these remedies.
Especially the observation that perhaps the governor shouldn't have or didn't have to go by the aid and advice of the cabinet, and that there was abundance of application of mind. Because these are 2 points that that you were arguing on, one of the main contentions of your team.
Insofar as the aid and advice is concerned, the governor is required to act under the aid and advice of the Council of Ministers. That's a mandate of the Constitution. It's a constitutional mandate. However, there are Supreme Court judgments that lay out exceptions as to when the governor can exercise his discretion. But is this a case where he could have exercised such discretion, especially when there was a cabinet decision to withdraw the show cause notice, or there was a detailed response from the Honourable Chief Minister, there was a detailed reply insofar as the Chief Secretary is concerned, there was an inquiry commission that was set up. So the governor must also accord reasons as to why he is differing from the aid and advice of the Council of Ministers, in the absence of which the burden of proof is higher on him, especially in these circumstances. He's in the regular course of things, he is required to act under the aid and advice, but to defy it under these exceptional circumstances, he must accord cogent reasons, which we believe hasn't happened. And let's see, we know where the Supreme Court judgments are in our favour, Nabam Rabia and MP police establishments. We will urge all these contentions.
So appeal before the division bench is one of the options for you now?
Yeah, that's the only option. We filed a writ petition and GM rest classification.
On that note, allow me to introduce to you our experts joining us this afternoon. We have Surabhi Hodegere, spokesperson of Karnataka BJP with us, along with advocate from the Supreme Court Sumit Chandar. We also have political commentator Paramveer Singh with us on the broadcast. My first question is to Surabhi. Given the political reactions coming in from the Congress, we've heard it from Deputy Chief Minister Surabhi, who has in as many words while backing the Chief Minister said that we will weigh in on our legal options, but this is pure political vendetta against Chief Minister Siddaramaiah.
First and foremost, I congratulate the people of Karnataka because today truth has triumphed in a way that it stings a little for the governing party, but so be it. We have been, as the opposition party here in Karnataka, we have been pulling this issue to the forefront, fighting through different, on the street, legally, etc., etc. But the particular case in question is the case of the Chief Minister questioning the governor's order for sanction of prosecution. And today the fact that this has been dismissed goes to show that one, our judiciary is committed to upholding constitutional values that clearly the Congress party has been negligent of. This was not a trial of whether Mr. Siddaramaiah is guilty or not. This was a mere sanction to investigate. How can we when there are such strong allegations, and this has been reiterated in the order today, that these allegations are not to anybody else but to the family members of the Chief Minister himself, who, mind you, has been in some position of power in the last 30 years, therefore is liable to have, those allegations could be true. Therefore, this is a matter of whether investigation should happen or not. Why should the Chief Minister be protected?
Viewers, the Chief Minister of Karnataka, Siddaramaiah, is in a lot of trouble. Now, I'm not just making far-fetching comments, viewers. I will base them on the excerpts of the judgment that was delivered by the Karnataka High Court. Ideally, on the back of that judgment, he should quit pending investigation into an alleged land scam that some say runs into thousands of crores. If there is a moral bone left in the Congress party, it should be looking to a metaphorical Bharat to sit astride the Chief Minister's chair. Siddaramaiah steps aside pending investigation. The reason is because prima facie, the High Court has upheld the state government's decision to grant sanction to prosecute Chief Minister Siddaramaiah. The alleged MUDA or Muda scam, as it's being called, focuses on the value of land allotted to the Chief Minister's wife, Parvathi, in an upmarket area of Mysuru as compensation for land that the Development Authority took from her elsewhere for an infra development project. The Karnataka High Court prima facie believes that the Chief Minister has a lot to explain. Why, for instance, did he gain, in a manner of speaking, undue advantage?